Could it be said to be part of the positives of the judiciary? Well, it's just a new feat of the Federal High Court of Nigeria constituting a special task force of judges to hear and determine all pre-election cases filed before it within 4 weeks. In relation to this, the Chief Judge of the court says it is necessary to designate a team of judges following the large volume of pre-election cases that have flooded the court. Judges who are members of the task force will suspend all regular cases in their respective courts due to the urgency of the electoral cases, which are time-bound. Will this really be implemented, especially with the clause that says the lawyers will have to put aside cases in their respective courts to attend to them? Well, this becomes the crux of our discussion on Nigeria Today. Thank you for joining us. I am Lydia Odijochi. Welcome to the program. The topic of discussion today is Special Task Force on Pre-Election Cases. And here in the studio is Jide Ojo, a public affairs analyst. Welcome to the program.
It's a pleasure. Thanks for having me. Good evening, Nigerians.
I also have a guest who is joining us via Zoom, Kayode Ajulo, a legal practitioner. Thank you for joining us.
It was my pleasure. Thank you very much.
All right. I think I'll start with you right away. As a legal practitioner, how will you assess this development?
Well, let me put it that it is a welcome development. Welcome development in the sense that there is a need to dispense justice, particularly when it comes to this pre-election matter. We should bear in mind that it is one of the fallout of the new innovation of the Electoral Act. But I'm talking of Section 84, subsection 14, where the Federal High Court has been given exclusive jurisdiction to entertain and determine a pre-election matter. You know, prior to that, all the High Courts, both the state, the FCT, and the Federal High Court, has the jurisdiction to entertain such. But now that the Federal High Court, which I'm very sure the numbers of the judges at the Federal High Court, they are not even up to 90 now, for them to take all the pre-election matter all over the federation of 36 states. We should know that it is not a Tea Party again. And it is expected that the justice must be done. All the issues must be resolved within a limited time. And all this means that there must be a lot of pressures on our judges. And I'm not talking of the entirety of the judges of the Federal High Court. And how it will be resolved, we pray this new innovation by my Lord Justice, the Chief Judge of the Federal High Court, we save the day. I think it's starting today. But the fear is it will have its toll on other matters, particularly criminal matters or the civil matter that traditionally the Federal High Court has been taking, because it seems that the court is going in some I won't call it vacation, because every other cases has to be placed on hold. How it will pan out, I think we are watching.
I'd like to hear your reaction on this development.
Well, like my learned senior has said, it's a welcome development, and this is part of the test case of the implementation of Electoral 2022. Recall that, we have this law barely about 8 months ago, on February 25, 2022, Friday. That's when the law came into being. And having excluded the State High Court from entertaining pre-election matter, definitely the Federal High Court will be overwhelmed and inundated. But it also indicates that our political parties have not done a very good job If people are still aggrieved, aspirants are still aggrieved to the extent that they are now overwhelming court trying to seek redress. Like Dr. Ajulo said, Section 84 sub 14 gave an exclusive jurisdiction to the Federal High Court to entertain pre-election matter. And when you look at the fact that, what's it called? For the first time too, we are having we are having party primaries concluded 6 months to election. The assumption is that this has given sufficient time within which to resolve all pre-election matter before election and before inauguration, so that we do not continue to have a scenario where somebody will not know of his candidacy until maybe the eve of the election, or even after the election will have won and lost. And then you now say, oh, this person did not qualify ab initio. Look at the case in Bayelsa, the case that brought Doyediri as the governor. Recall that it was a pre-election matter about the candidacy of the running mate of David Lyon. But you know, it was a pre-election matter. The High Court gave a decision. It went to Court of Appeal. The Court of Appeal then up to Supreme Court. At the end of the day, election has been won and lost, only for the court to now say, oh, you did not, your deputy or running mate was not qualified, and as such, you cannot, you know, benefit from the electoral victory. Because we also must understand that this is, Federal High Court is a court of first instance, which is why what my Lord Justice Stoll tried to do is very creative. He has said that this issue should be resolved in the next 4 weeks. So these cases, criminal and civil cases that have to be abandoned, will be just for 4 weeks. After which the judges will go back to entertaining the other schedules that they have. But one thing we also must learn is that Federal High Court is still court of first instance in resolving this election pre-election matter. The case will still go on appeal in many instances up to Supreme Court, because you know, this is a case that just does not have only Federal High Court jurisdiction. So an election is just less than 120 days away. So the justice delayed is said to be justice denied.
Okay, Dr. Ajulo, let me come to you. Like he said, just 4 weeks, to dispose of these pre-election cases. Now, do you think this timeline is enough to clear all these cases?
I believe that the timeline is enough. What we should be interrogating is the number of the judges to take over, to take these issues. In a situation where we have enough judges, it is possible. But in a situation where a single judge will be allowed to take over 20 to 30 cases, that is where the problem of the timeline will not be what may help the issue. So we should not be talking of the timeline. We should be talking of the availability of the judge to do justice to the matter. And I must say this, that our judges are being overwhelmed with cases. In the normal client, I don't think it would be too much for a judge to take 3 or 4 cases in a day. But today, sometimes you get to the courts, you check the cost list, you will see nothing less than 25 to 30 court cases. And sometimes you wonder, how will a judge will sit for 6 to 7 to 10 and 12 hours over a case? You know, it will even have a toll on the judge. And I think if one has his way, but unfortunately, before you can change that, the minimum number of the judges and the minimum is already enshrined the Constitution. So it means sometimes that the constitutional provision has to be amended. But the problem is not about the timeline. The problem is about the number of judges available to dispense the cases.
Of the view that the possibility of denying some individuals access to justice because of the swiftness in the disposal of the pre-election cases cannot be overruled. This could send probably it could send tension in the political scene. How would you react to this?
You know, when it comes to access to justice, access to justice for me should not be on class issue. Access to justice should be for all. And before we have this, it is always believed that criminal issues, criminal cases, as it affects the rights of the people, should take precedence over anything. And that one is quite clear, because we are talking of right, which is the ultimate right. But unfortunately, the political cases seem to have overthrown the rights of the people. There are times that the criminal matter will be there for donkeys of years, whereas the political matters. I'm not saying the political matters never matters, because it is when we get our political situation right, that's when we can believe that we have a government, we have the people that run the affairs of our people. But I believe there is a need to create a special intervention, particularly since most of these political matters always seems to be seasonal. We have this periodic. We know that between now and next year, the court will be so busy. I don't see any reason why there must be a special provision, maybe in form of even drawing some senior lawyers, senior advocates, lawyers that are already exhibit high standard, high in the industry, to even help in dispensing this justice. And even if it means that drawing some already retired justices to come to salvage the situation, I think it would have been, even with that one, we may even have a hard work justices, even if it means that to bring some from the magistracy to come over. I think that would have been better. But to now pull the judges from their normal cases, and then, because as it is like the justice on standstill, pending until after the political matter has been cleared before we can experience the normal flow of justice. I think, to me, is worrisome to somebody like me.
Now, Jide, how can the country minimize this large or such number of cases in the future?
Again, first and foremost, I think we need to know exactly how many cases are we talking about. How many? Because even as I wait for this program to commence, a decision has just been given in Nasarawa Central District election. So on daily basis, you have cases already being disposed of at the High Court level. So we need to know how many do we have left as of today. That 1 month will count. So it's then we can talk of sufficiency or insufficiency. But having said that, coming back to your question, how to prevent deluge of election petition, in pre-election petition, is for the political parties to do the right thing. It's the fact that they didn't do the right thing that makes people to feel aggrieved and to go to court. And it is even better that they are going to court rather than resorting to violence. Because what if they call out their supporters and they start destroying or assassinating themselves and destroying public property? That would not be a better alternative. And one other thing I think we should also highlight is the role of alternative dispute resolution. Why are the political parties and aggrieved candidates, why are they not availing themselves of ADR mechanism? There is mediation, there is arbitration, there are other alternative dispute resolution. We call it electoral alternative dispute resolution. And INEC has established a directorate for that, which can also help in facilitating the resolution, amicable resolution for that matter, of these pre-election matters. Because we cannot shut people out of the court and say, oh, because you don't want the court to be congested, don't go to court, don't go to court. The point is, one, the political parties need to behave themselves, particularly the gatekeepers who conduct sham, party primaries, which made people, because you cannot collect that huge sums of money that people pay to buy nomination and expression of interest for, and you won't get justice. Even if you are going to lose, lose that you know that you have lost gallantly. So it's when you don't do the right thing at that level of party primaries, or you screen out people unnecessarily, then they will have no choice but to go to court. But let them avail themselves of electoral alternative dispute resolution, and maybe we should call up retired justices who have not soiled themselves, because some of them, don't forget, were forced to retire based on allegation, corruption, allegation against them. So we should also be selective, even if we are going to draw from the bank of retired justices.
Okay, now let's go on the break. We'll be back to talk some more. Stay with us.
This is NTA News 24 broadcasting from Abuja. You can watch us anywhere, anytime on the following platforms.
Start Times, Channel 101, Freak TV, Channel 703, GSTV, Channel 419, and Go TV, Channel 46.
For more information, log on to our website, www.nta.ng, or join us on our social media handles, Facebook at NTA News 24.
For comments, suggestions, and inquiries, send an email to news24@nta.gov.ng or call us on the following numbers.
NTA News 24,
news and more news.
Welcome back. The program is still Nigeria Today, and the focus of our discussion is Special Task Force on Pre-Election Cases. Still with me is Jide Ojo, Public Affairs Analyst, while Dr. Kayode Ajulo, a legal practitioner, is joining us via Zoom. Okay, let me still stay with you, Dr. Kayode. Could you enumerate some of these things that may have necessitated the establishment of this committee, or what really is the motive or the move? What is the move really said to achieve differently from what was obtainable?
I will need to be sincere that my Lord, the Chief Justice, has to be commended for even taking that innovative idea and ensuring that at least it will bring some sanity to the potpourri and the cacophony of election petition that is being filed in every federal court in Nigeria. But the mode, like I said, is of mixed reaction in the sense that some cases are on hold now. The justice seem to be arrested to those people, while two others, particularly the political class, justice is working for them. And based on that, certainly it will cause some sense of mixed reaction. And maybe to what my brother mentioned about the fact that the election petition, the election has to be, we need to get our election right. The truth of the matter is that in a way, whatever way you conduct election, either good or bad, some people will certainly go to court, because here we're talking of issue of power. It's struggle for power. That's when you have controversy, you have a strife, you have all those. And going to court sometimes is another way, another method, another mode of struggling for that power. So we can't rule people going to court, because that is the essence of access to justice. What matters most is to have mechanism in place to ensure that whatsoever thing that is happening is well managed, well coordinated, and good for the entire well-being of the country.
All right. Now, Jide, let me ask you this: does this really have a constitutional backing, and what will be the difference between this and a tribunal?
Well, this is we are moving into the realm of technicality now. A tribunal and a task force, it depends on the way we have military tribunals, we have faith bank tribunals, and the law acknowledges and accepts all of these as ways of dispensing justice. So the task force, a tribunal can be a task force.
Okay.
panel of inquiry can be a task force. There are different ways by which you can establish task forces by different names, and all aimed at dispensation of justice or resolving a knotty issue. So the judiciary is the one that, between the judiciary and the executive, they are the one that uses this methodology to resolve issues more. You find out that the president will set up task force on this and that. These are administrative ways of dealing with issues, emerging issues. And of course, I don't know if we have had previous task forces on judiciary like this. This seems to be new, given the fact that, yes, I recall that the president has been even advocating for special courts to resolve corruption cases because of his perception that it was drawing too long. You recall that when he came into office in 2015, he actually said he discussed with the leadership of judiciary at that time to say that there should be special courts that will handle only corruption cases, which is also what the law now determines, that there should be election petition tribunals. You know, they call it tribunals now, which is also like an ad hoc. It's not like it's an ad hoc thing, more like a task force to deal with election petitions. Now, what this has done is also setting up this task force is also an ad hoc contraption, ad hoc committee to also resolve a issue, a legal issue, in a judicial way. Because the reason why it's a task force is that this is outside of the normal court processes. You know, what we know courts to do is to entertain civil and criminal proceedings. But lawyers will tell you that election petition is sui generis. It's unique on its own. It's unique, and that uniqueness also, and that's why they have to issue practice direction to back up some certain decisions of the court. But all aimed at resolving a nagging challenge, which we know, and you know, like we said, justice delayed is justice denied. Election has a date. Some criminal cases, some civil cases, it doesn't matter. There is nothing spoiled if they take a longer period. Although Administration of Criminal Justice Act 2015 has also encouraged fast tracking of judicial processes on criminal cases, that it should not be more than 6 months. But we know that, you know, due to certain challenges, we still have criminal cases lingering for years rather than 6 months that was initially envisaged. But because election is sui generis, and this pre-election matter, now we are having it growing in numbers because of the interest people are showing in the political process. And even when you deal with this, this is just part one, scene one, act one, scene one. Because after the election, you still see the same gladiators approaching the court. This time, it will not be normal court or federal high court as the case with this pre-election matter. They will be approaching the election petition tribunals, which will have been set up at least some 14 days before the election.
Well, we hope the objective will be realized at the end of the day.
That's
we'll now call it a day on Nigeria Today. Special thanks to our two guests, Jide Ojo, public affairs analyst, and a friend of the house. Thank you so much.
My pleasure.
I also want to appreciate Dr. Kaede Ajulo, a legal practitioner. We appreciate him for his time with us and thanking him for joining us despite his busy schedule. Also, we appreciate you, our viewer, for staying with us on Nigeria Today. The program airs weekdays at 7:30 p.m. on NTA News 24. And you can watch this episode and other ones on www.youtube.com/NTA24hub. Once again, thank you for being a part of the program. I am Lydia Odijochi. Bye for now.